Welcome back to the Double Loop Podcast. This is going to be our 10th episode. We've made it to double digits now. So I want to welcome all you very voracious and vexing verifiers out there. While you're doing your comparisons, we'll talk about comparisons. I'm Eric Ray.
And I'm Glenn Langenberg.
Look, Glenn, we made it to 10 episodes so far, so it looks like we might be doing something right here.
Yeah, I know. I'm actually pretty happy about that. We'll have to just keep this train chugging along.
And looks like we got a very interesting topic to cover this week. It kind of, blew up on all sorts of different websites and email groups and message boards this week. So we'll get to that in just a second. But how's your week been going so far?
It was a pretty laid back week. No, nothing too momentous. Kind of getting in the rhythm a little bit of this section. I can't say that. It was fairly neutral week, I have to say, other than the big news story towards the end of the week.
Well, I got a little bit of news to share. Penny Decison and I, who's a tech lead with me here at Arizona DPS, we have a class scheduled through RTI, which does a lot of online training, and we're going to be able to do our shorter version of our class on exclusions through RTI coming up next month. It's going to be November 20th and 21st. Sorry, go ahead.
I saw that, actually, through the RTI website.
So, yeah, we've been working with the guys there for a few weeks now, kind of working out the details on exactly how that's going to work and how we can present what we've been doing at different conferences over the past year or so through this online forum. And I think we worked out something pretty well, and we're hoping that it's a valuable and useful class for people to go to, even if it is through the internet. We still have our 3-day version of that class with a lot more hands-on involved discussions on even more topics. But for what we've done at Providence, back at the IAI, and a few other conferences, this will be kind of that same material that we did at the conference.
Yeah, one of the drug chemists actually brought it to my attention. She said, hey, there's this class on exclusions. And I thought she was talking about drug chemistry exclusions. If you recall, in the last episode, we talked about that a little bit.
Right.
Right. And so when she brought it to my attention, she said, here's this Reducing Erroneous Exclusions workshop. I went, either someone is copying Eric's class with the same title and everything, or Penny and he have the workshop, through RTI. And then I looked a little bit further and saw Arizona DPS, and I said, oh, yeah. I told the chemist, oh, yeah, I know them, I work with them, I even do a podcast with one of the instructors.
An excellent podcast with one of the instructors, I might say.
Yeah, so congratulations, that's cool.
Yeah, no, we're really excited about that. Well, we'll just kind of see how it goes. This will be the first time for both of us to do a class through the internet. Maybe this podcast is a little bit of practice getting ready for that, for me at least.
Sure. How do people sign up for it if they want to sign up for the workshop?
All right, well, if you go to rti.org and then click on their Education and Training tab, and then on their Forensic Science Education tab, you should be able to find your way to the right area to register for that class.
Fantastic.
Well, Glenn, shall we jump into the topic of the week here?
I think so.
Well, why don't you start off? Give us a little overview of what happened to our neighbors to the north.
All right. Well, if you haven't heard the news yet, there was essentially a rejection of fingerprint evidence in a Canadian court, in the Supreme Court of British Columbia, in the case of Timothy Dale Bornyk. I think, now that's my best stab at it. It's Bornyk. If you go to Google the case, Timothy Dale Bornyk. That's how I'm going to say it. And it looks like the justice in the case, Mr. Justice Funt, F-U-N-T, which I suppose that's somewhat appropriately named. Do you remember Alan Funt from the 70s, right? Right, Eric?
Well, briefly, and maybe reruns in the 80s as well. But, bloopers and practical jokes, right?
Oh, and Candid Camera.
And Candid Camera, that's right. I'm mixing up my TV shows.
Yeah, this has a sort of candid camera feel to it. The judge in this case has, well, reviewed the evidence that was provided, by a fingerprint examiner from the RCMP in this case. It was a burglary case, and they heard evidence, it looks like, in Vancouver area, British Columbia, in April, July, September, October. It looks like they had a number of different dates and trial dates. And ultimately, the judge made a decision on October 22nd that essentially to dismiss the fingerprint evidence and acquit the accused. Basically, the fingerprint examiner had identified the suspect to a single latent fingerprint that was found at the crime scene in the home, presented the fingerprint evidence at trial. I'm based on the testimony, it sounds like the charted it out and showed the corresponding features and the ridge comparison that he did, but ultimately the judge didn't believe the evidence and in fact did his own comparison, and in his opinion, in his lay opinion, he couldn't see it. Essentially, that's what he was saying. I don't see the match. I see some similarities, but I also see some differences, and so therefore, I don't think it's a valid identification. Rejected. And that's the story.
Do you think the judge is going out on a limb there of trying to make a name for himself? Or is maybe he always wanted to be a fingerprint examiner and this is like his way into the discipline? Just jumping right in with this comparison, or do you think there's any kind of motivation behind this decision?
Yeah, I can't get any sense of that. I mean, at first, as I was reading the decision, I thought I knew where this was going. I thought this was essentially going to be I'm not going to allow him to come into the courtroom and say, to the exclusion of all others, 100% certainty, it's him, he's the source of the latent print, and no one else. I really thought it was going to go in that direction. So it surprised me when we got to the end and he said, and then I did my own comparison and I don't see it, so I'm acquitting him. I would say it threw me for a loop.
Yeah, it was a kind of an interesting decision, and it's out there if you guys look around. We're still working on getting our podcast website available, otherwise we'd put it up there. And we'll probably eventually, if you're listening to this months down the road, get all this information posted up onto a website so it's easy to find. But it's still out there at probably clpex.com and other websites and other methods to get at this. But he makes some very interesting, I guess is the one way to put it, arguments of why he didn't believe the ID. Some of which I actually thought were at least fairly reasoned, and others which are just wildly out there and kind of new approaches to how to deal with fingerprint evidence in court.
What were some of the ones that you thought were pretty good? So
going over a few of the things that he listed out in his own research. Well, let's back up a little bit first and tell a little bit more of the story here. It looks like he was hearing some testimony from this fingerprint examiner, and then went home that night, got on Google, which can be dangerous, I would venture to say, and started doing some of his own research. And he came in the next day with 4 articles that he would use to make his decision in the court. These aren't articles that the defense brought in, but just things that he found on his own. The first one was the Scotland Fingerprint Inquiry Report, kind of the final word from the McKee case. The second being the NAS report. The third, the NIST Human Factors paper or book that came out. And the fourth, an article by Simon Cole. Which, personally, I have issues with all 4 of these of these reports or books or articles in
references.
Well, yeah, references. Exactly, but I mean there are definitely some good points raised in each of these, and these are all major things. These aren't things reports or references that are completely out there, but there, in my own personal view, issues with each of them at some point in each article.
Although one of them, the human factors one, clearly talks about the importance of expertise and why experts should do this and not lay people, which is a bit ironic.
Exactly. Well, it's big. You know, he may have not read that specific part of the.
He has skimmed over that chapter.
Exactly. But so then he took all those and compiled everything there, and went forward with some major points. One being that the verifier didn't come in to testify. All the word in the court about the verification was hearsay from the original examiner. And again, not quite sure all the workings of the courts up in Canada, but from some of the transcript that's listed in what the judge wrote up, seems to be at least wording that we wouldn't use in Arizona, at least, in talking about a verification. What was your impression of that part of the testimony?
Well, I don't remember the specifics or exactly what you're getting to. I just remember your point that the verifier didn't testify, but I didn't see what essentially a big deal that was, other than the fact that he noted the Langille case, which notes verification testimony if that person is not there as hearsay. So essentially, you have to disregard anything in reference to verification because the verifier was not there. So you're essentially testifying to someone else's conclusion when you say, and this latent print conclusion was verified by another examiner. And again, depends on certain states. Some states don't have a problem with that. Minnesota, for example, doesn't. It's often there's an objection, but the judges that I've had have always allowed me to talk about the verification step. We know in other states, even talking about verification at all could, it could in some instances even signal a mistrial or issues, as we've seen in a few cases.
Right, and in Arizona, we haven't really had any issues with it come up, but we're taught and encouraged when going in to testify that when the verification topic comes up, that you discuss it more as a general case, how verification is part of the policies for our agency, and that in this case I followed all the policies, not specifically mentioning verification as it pertained to this case or even bringing up the specific examiner that verified the work in this case, but talking about this is what our policies are, and in this case I followed all the policies.
Right.
He had an interesting perspective on how the RCMP works with not tolerating any bad IDs. Looks like the examiner testified that if he were to have made a bad ID at some point, and he's not aware of any that he had made up to that point, then he would not be doing this job anymore.
I did read that, and to be frank, I think that is where you started to get into some of the traditional fingerprint culture.
Exactly.
And knowing some of the RCMP guys and how they would testify. I mean, if you're talking about sort of the strict Canadian way of testimony. This doesn't surprise me, of course, and I've heard this over and over in that culture of fingerprint examiners, as it was here and it still is in parts of the United States. This notion of if I make an erroneous identification, I will be out of a job, and that may be the case in the RCMP. Which, and as you pointed out, there's a difference between saying I've never made one versus I'm not aware of one.
Right, and the judge in this case took that as actually a bad thing, not a good thing that the RCMP has this extremely high standard, but that the high standard may lead to errors not being brought to light because you want to kind of stick up for your coworker.
Well, I mean, he actually says that in itself that type of culture would lead to a bias that if you were on the borderline, rather than call your colleague out and go, no, I don't know if there's enough here to call this, or I have issues here, it's safer for everyone to just agree with the first examiner as opposed to disagreeing, and then someone is potentially, quote-unquote, out of a job.
Right. I wouldn't necessarily go as far as the judge did in saying that having this high standard leads to this kind of culture. I mean, it may having that high of a standard may lead to some problems, but it doesn't go so far as to call into question every identification that an agency makes. It seems to be that the culture is starting to change a little bit in not having as pervasive this kind of culture in all agencies, at least in the U.S. Is that what you're starting to see as well, too, Glenn?
Yeah, I mean, maybe I'm more sensitive to it because, like I teach workshops. My workshops deal specifically with error rate and talking about error rate. So, I'm a big proponent. Well, and as you know, even in the Advanced ASB course, I'm a big proponent of how we should be testifying to error rates. I can take a little aside here if you want, Eric. I pulled an article that was sent to me. I had asked for another article on error rates, which if we get to in today's podcast, that's great. But it's from a group of researchers. You may know the name Tangen and Thompson, and they're in Australia. And in this particular, they had done work with experts and lay people and measuring error rates. But I was asking about a new study that they had on error rates, and again, if we get to, we'll talk about it, or maybe next episode. But the guy I was talking to, Matthew Thompson, he was at the II. I think it was at the Phoenix II.
I remember meeting him there. Yeah.
Okay. All right. So, real nice guy. He's finishing up his PhD. He's working with Jason Tangen, who is the psychologist who was running some of these experiments in Australia, and then throw in Gary Edmond, who's a professor there as well. And so the three of them wrote this paper, and it's called A Guide to Interpreting Forensic Testimony, and it's in Law, Probability, and Risk, and it's 2013, and about 25 pages long. If anyone wants the article, I can send you a copy if you email me at glenn@eliteforensicservices.com. But throughout the article, it talks quite a bit about it talks about the Human Factors Report, talks about the Scottish Fingerprint Evidence Report, talks about a great many things about the history of error rate testimony, and the NAS report, and all these different groups have sounded off on this. And then somewhere about halfway through, it gives a guide to error rate test, or to forensic testimony, and just discusses error rates and how to talk about them. And I really like what they put together. It's very similar to how I would testify in court as well, and especially when dealing with error rates. So I just thought I would read this. It's a nice little box that they separated, and I'll just read it from the paper if you don't mind, Eric.
Sure. Go ahead, right ahead. I haven't seen this yet, so this will be great.
Okay. All right. So they start talking about here's what we recommend. It's a guide to forensic testimony for fingerprints, and they actually preface it with, "You're going to find this very controversial." And I was waiting for it, and when I read it, I went, "That's actually that's pretty close to what I would say." So reading what they wrote, it says, "A guide to forensic testimony fingerprints. A decision about whether two fingerprints match or not is based on the judgment of a human examiner, not a computer." That's sort of point one. Any problems with that, Eric?
No, I would completely agree with that. The computers get it wrong way too often.
Right. So you basically say that it's a human decision and it's based on human judgment. Okay, great. So it's an opinion and it's a human decision. And then the next talking point is, there are several documented cases where an examiner has incorrectly said that two prints match, quote unquote match, when they actually came from two different people. Laboratory-based experiments suggest that errors of this sort happen infrequently, around 1% of the time. That's the next point.
That also sounds about right. I mean, there's been quite a few papers published that put the error rate on average for your average fingerprint right around 1%. So
yeah. If anything, I probably would have just tweaked that to say approximately less than 1% of the time. And I guess it'll depend on which papers you're referring to. But I like the distinction between there have been documented known case errors, and then separately there are laboratory-based experiments that suggest these sort of errors happen infrequently.
Right. I mean, 1% would be for much more difficult comparisons, but through all the research that's out there, that would be, fairly fair.
Yeah, I can live with that. And then the third point is, in practice, however, it is unknown how often examiners say the two fingerprints match when they actually come from two different people. That's the third point.
Which is also true. There's really no way to find that out when all the comparisons done in an actual agency are all real cases without ground truth, so there would be no way of measuring except to, in general, kind of rely on the generalities of the fingerprints in tests being mostly similar to ones in actual casework, and then extrapolating from there.
Right? Or we might be able to measure that if we do, say, blind proficiency tests where examiners are working them and aren't aware that they are tests where the ground truth is known and they're slipped into your case stream. Then we can begin to measure in practice those types of things. But for now, I agree. It is unknown how often erroneous identifications happen in casework. Okay. So the fourth point, and this is what I like, because I don't know if you remember from the class or the workshop, I like how they talk about the general, but then they go to the fourth point here, which is, without specific evidence, it cannot be known whether an error has occurred in a particular case. And I really like that phrasing. Without specific evidence, it cannot be known whether an error has occurred in a particular case. If you recall, Eric, my answer was, in any case, there's a theoretical possibility of error, and that probability of an error is dependent on lots of different factors, such as the difficulty of the fingerprints, the case details, etc., etc., etc.
Absolutely. And if you are a defense attorney out there and you have question about the correctness of an identification in a case against your client, just looking at history of the errors that have been brought to light and have been shown to the rest of the community, your best bet is to have another latent print examiner look at that comparison, because that's how errors are found. I can't think of any bad ID that was found any other way. Glenn, am I missing something?
The Collins case. It was it was DNA that sort of exposed that one. That's the only one that comes to mind. Okay.
How about the vast majority of the bad IDs that are discovered have been brought to light by fingerprint experts?
Yes, I would agree with that.
But even in that case, wasn't it eventually then a latent print examiner that re-looked at the comparison?
Yeah, I suppose that's fair. Yes, that would be true.
Okay, not that it's perfect, but that's the way these errors are found. And even going back to the NRC report back in the 90s when they were dealing with DNA, how does that paragraph read? A theoretical error rate for an entire discipline isn't really the point. It's the possibility of an error in this case, and there are many factors that would go into an error in a specific case that can be discussed, where a general overall theoretical error rate isn't really the point.
Yeah, I would agree.
I'm completely paraphrasing from that from that, but the NRC report that I'm talking about is at least those paragraphs are brought back up in Henry Swafford's article that he wrote in the JFI. I want to say January of 2012. If you have that issue, you can go find his article and read through the little section that I was paraphrasing.
Okay.
And that actually kind of brings me back around to the next thing that happened. It wasn't just that this judge brought up these 4 articles, is that the prosecutor then also presented the judge with 3 more articles. One from Heidi Eldridge, an article from you, Glenn, your pilot study on the accuracy of ACE-V.
Right, and the BCA black box study that we did.
Exactly. And then the Resniak paper on ACE-V and the scientific method.
Right, comparing the ACE-V quote-unquote methodology to the scientific method.
And, I thought these were interesting choices to bring up, before the judge. I may have.
I thought so too, Eric. I mean, of all the papers out there, those, frankly, I mean, I know different things about all these authors, including myself. Those would not have been the papers that I would have necessarily have presented to the judge.
Yeah.
If you gave me, pick 3 papers that you need on your desert island or you need to give to a judge, those would not have been the 3 I would have chosen.
Exactly. Yeah, that was my first impression too. I looked at those 3 and went, well, I mean, they're good articles, but I don't know if they were the best 3. And I don't know, maybe it seems like the judge just showed up the next morning with these 4 articles, and it was maybe the prosecutor didn't have as much time to kind of prepare for what was about to happen. I would guess the first thing out of my bag would have been the black box study, the Ullery, Hicklin, et cetera, Noblest study that talked about the specifics on a large scale about the accuracy of latent print decisions.
All right, and the other one that would come to mind right away would be Cedric Newman's study, where he demonstrates the specificity and the power of fingerprint evidence, the theoretical foundations of how discriminating fingerprint features are.
Exactly, and I think it was those folks down in Australia, Tangent, et cetera, that had a paper on lay examiners versus expert examiners and how well they do on comparisons. Am I picking the right people out with that?
You are, although I would imagine that the prosecutor was not anticipating that the judge was going to be relying on his own interpretation.
Right.
So I mean, without knowing he was going to do, if I had known that he was going to do that, yes, absolutely, that paper would be right there. But if without knowing that, that would have been very difficult to anticipate.
Exactly. And then the last one, I just mentioned it a few minutes ago, the Henry Swafford article on the admissibility of fingerprint evidence, which kind of goes through all of the Daubert criteria and how latent print evidence meets each one of those. Not hard evidence-based paper like the other ones we've mentioned, but I think that might have done a little better job than these other ones on demonstrating in more legal terms how fingerprints are acceptable in court. Some of the other things that the judge brought up, it just had me scratching my head on some of these. One was that he didn't get to see a copy of the bench notes of the examiner, which had me kind of curious. I would think, I know that RCMP is kind of way out there on the forefront of documentation and being really open with everything that goes into an identification. Is my impression right there?
No, you're correct. In fact, they talked about the corporal's friction ridge analysis report, which is very Ashbaugh. I mean, if anyone listening has taken Ashbaugh's class, you prepare one of these types of reports, and it's a very detailed, documented report on the friction ridge analysis. So I suspect, as opposed to seeing handwritten notes or something like that, they were reading this report because that's what the judge talks about.
Got it. So maybe the bench notes were there available? Is that what you're saying?
I don't know if they were made available or not. I mean, the corporal submitted his friction ridge analysis report and testified to it. I don't know because it sounds very much like this was a bench trial. So perhaps there wasn't a typical discovery that you would have expected, where a defense attorney would say, "Show me everything you have, including these, and that." And I don't know if that would have happened in a Canadian bench trial. I see where you're coming from. I was a little confused by that, but again, I'm guessing that just the report was submitted and that was what was testified to. And again, you have to assume there was a little bit of routineness with this case being a burglary that and not a formal defense challenge like some sort of Daubert hearing where everyone was expecting and preparing in a Daubert fashion.
Right. I'm sure that most listeners out there are very curious about what the fingerprint looked like, and we've actually had a chance to look at least at the latent print from this case, and they describe it a little bit in the transcript that we have available.
Opinion, the published opinion.
Exactly, the published opinion.
We don't have transcripts.
sorry, yes, you're right. The published opinion from the judge, which has sections of transcript in it. And it appears to be a delta from a finger on the a left delta. So the pattern would be either a right loop or possibly a whirl. And I don't know about you, Glenn, but I got to about 16 pretty easily without too much trouble. Even there is some issues with the item that the print was on. There's some like folds and whatever the surface was off to one side of the print. But it
did you not see what the surface was?
Oh, that's right. I read it in the report. There was some sort of packaging from a...
Eric, I'm shocked. No, it was a zombie doll.
A zombie doll, yes. No,
how could you not have noticed that?
Of all people to miss that it was a zombie doll. With Halloween coming up next week too. What was?
Yeah, I know.
Or later this
timing.
Week. Exactly, perfect timing. Needless to say, the little bit of folds in this package of a zombie doll weren't enough to get in the way of the rest of the print. And am I right there? Were you able to get up to about that number without too much trouble?
I'm looking at it right now, and I gotta say, this is a beautiful latent print. I mean, this is exactly the type of high quality, high clarity latent print you would categorize as a relatively easy one. There's minor smearing, minor drag, very, very minor distortion. As you say, it's fragmentary, given some of the nature of the evidence and where it's located. But I mean, I assume you're thinking the same thing. The clarity is very, very high.
Absolutely. I mean, we don't have pores, but we basically have just everything short of pore structure in this print. It really is beautiful, and they even got the scale in the side. That's nothing more that you could want out of this print. It is, again, with 2 trainees now working with them every day, I would be pretty comfortable, even though they just started giving this print and being surprised if either of them missed it, because there is overwhelming detail available in this print to compare. Now, I haven't seen the exemplar yet, but if everything in the latent matches up, then this is an easy one. This is the kind of detail that, if everything is in correspondence with the known, would put it above DNA numbers for in whatever likelihood models might be coming out in the future.
Well, and that's one of the reasons that I would have noted the Cedric Newman article, is because in the time that you were speaking there, I was counting the number of minutiae I could observe, and we're talking easily 16, 17, 18 minutiae, relatively clear. Although, yes, in the delta region, it expands, at least 12 ridges up and then in towards the core as well. So, I mean, a pretty good amount of surface area. This is not a small print. I mean, it really covers from the core all the way over, even sort of beginning to extend up towards the tip. I don't know if this is a thumbprint or not, but it sort of extends a bit towards the top.
And that was one of the judge's problems with this print, which is kind of strange, is that it seems like the latent print examiner was asked just asked to describe his comparison. And as he was going through, he made some mention that his initial analysis, he wasn't able to determine which finger it was. And the judge seemed to latch onto this as some ambiguity of if you couldn't tell what finger it was right away, just by seeing the delta, then there must be some sort of problem with the comparison, and it must be a distorted partial print with issues. And
as you're saying that, I'm remembering reading that now, and that did stand out. That was some bizarre logic.
And it just doesn't seem like he understood that that's not, with adjacent fingerprints or with certain patterns, we can generally tell which finger is more likely to have been the source of a print. It's fairly rare to be able to tell just by looking at a latent print exactly what finger it is, and be sure of that right away. He made some comment about how you couldn't tell what finger it was until you looked at the knowns, and then once you did the comparison to the knowns, then you could find out what finger it was. And I was reading that thinking, well, yeah, that's kind of the point. That's what we do. That's
right. Well, and that's pretty much like looking at DNA and saying, before you even start to do the comparison, if you can't tell, what family this is from, or looking at this white powder, if you can't tell what drug this is, or before you do your comparison, well then, what value does it really have?
Right. So, a few other things the kind of more in the out there category. He questioned the identification because it was made to a photocopy of the exemplar card, which, I mean, while photocopies may not be the best reproduction of original evidence, it would in general be up to the latent fingerprint expert to decide whether or not there's sufficient, whether or not the photocopy is sufficiently clear to make the comparison.
Right. So, I mean, in all here, Eric, how much of this do you think was a case of the judge maybe not liking or appreciating the testimony so much? I mean, you have a examiner coming in who is, I'm going to assume, very confident, has testified probably in many cases, or at least a sufficient number of cases, and and knows the party platform. It's him. I'm trained, I'm experienced, I know it when I see it, I follow this procedure, when I don't make mistakes, I'm sure when it's him, I'm never wrong. I mean, how much of that do you think sort of led the judge to going, I'm going to look for anything I can to sort of disbelieve this in light of all this other, I guess, more well-known criticism like the NAS report and like human factors and these types of reports where there's this kind of growing thing? I mean, do you think that it could have been in some way the testimony that was off-putting, or do you think maybe it was, like you said, the judge is looking to make a name here?
I don't know. I might put it somewhere in between there. Just from the little bits of the transcript that are included in the judge's published opinion, I don't see any major problems with the testimony. So, I guess looking at the
I saw a few things. And I don't mean problems, but things that stood out. The sort of no doubt, absolute certainty. I never make a mistake. I've never made a mistake. Even in training, if you make a mistake, you're out. I mean, those types of things tend to set off some of the judges' bullshit meters. I mean, frankly, I mean, I think for some judges, and again, I'm not. This is not against the examiner. I'm sure he testified exactly the way he was trained to testify.
Yeah.
It's more of this culture that if it doesn't change, I mean, I think we see some of the effects. I mean, for us, we saw the Brian Rose case where Steve Meager testified the way it had always worked. It had always worked in these previous cases to testify in this manner, and that in that instance he caught the wrong judge that went, oh, whoa, hold on, hold the phone here.
Maybe that was kind of the instigating factor that sent the judge home and started poking around on the internet. Maybe he was just bored that night because he wasn't interested in whatever was on CBC or cable channels that night.
There was no good hockey on.
Sorry. I actually worked up in British Columbia for a 3-month stretch up in Quesnel for any of our northern neighbors listening. It's about an hour's drive south of Prince George, And
do they watch Terrence and Phillip up there?
No, but they're big fans of the Trailer Park Boys, and I didn't get some of that humor, but it's okay. Between 3 months there and 3 months in Alberta, came back with a little more appreciation for Canada and all that it has. So I enjoyed my time up there, but learned a whole lot. Like -40 is the same in Celsius and Fahrenheit, which growing up in Arizona, I had no idea. But I think maybe he started looking around. He read some of these articles, and there's this thing started going off in his head of it's just one ID. That's it. There's no other evidence in this case. It is one ID, and he maybe kind of extrapolated a little bit too far past this one really good clear ID, and in his head linking it to Mayfield or some of the other errors that have happened and were mentioned in some of these articles. And once that happened, he just started looking for little differences. So when he got to look at the print again the next day in court, he started making too much of the differences that he saw between the two prints, and not being an expert, didn't realize that the differences were not, they were the explainable, understandable differences if you understand friction-rich skin, and not differences that would discount this identification.
Well, assuming that, and I'm fair game to say a valid identification, but without seeing the known, of course.
Right. But
I can't see how someone that trained and of the highest caliber, like the RCMP, would get something this easy. This, like we talked about, this latent is relatively easy latent print.
Exactly.
I can't see him getting it wrong.
Yeah, exactly. And then going all the way to court, and then not noticing any kind of mistake by the time you get this far into the process. I just can't see that happening either.
So maybe you hit upon it a little earlier that it could have been some elements of the testimony that might have just made the judge go and do his own homework, and this homework led him down this inexorable path that basically ended up with him in the end playing expert, which again, if he doesn't trust the fingerprint evidence, the examination or the examiner, I'm surprised that he would, as opposed to saying, I don't find this to be reliable evidence at all, I'm just not going to consider it, for him to then engage in the practice himself. And it's a darn shame he didn't find some of the studies that showed how poor lay people are at doing this.
Exactly.
That it could have been useful to him.
The other thing, just the last little thing I want to mention that he wrote about was his concern in that the initial APHIS search didn't find it, and that APHIS presented this individual as a candidate later on through like an unsolved latent database. And he had some questions about, he felt it was unexplained as to why APHIS or the computer didn't find it the first time, since this individual's fingerprints were already in the database. And I'm not sure if the examiner had a chance to even explain that, or if he was just thinking about it later and just wrote it into his opinion. But I mean, this is all fairly standard things that we would have to explain in court, and how common it is for APHIS to miss prints like this, especially for this latent print, which looks to have most of its points on the outside of the delta, which may not always be recorded if the prints aren't completely rolled.
Yeah, good point.
So, in general, Glenn, I'm really curious. How do you feel when non-experts, whether they be critics or attorneys or judges, when they basically come up and say, you should be doing this, and they list off whatever kind of list of things they think you should be doing, and that right now we don't believe you, or until you do this we don't believe you, or I don't think I'll ever believe you because we don't think you can come to an identification that's provable in court. What's kind of your reaction when that comes at you from wherever direction?
Well, my general reaction, because it only does seem to come from the legal community, when it comes from people with a scientific background, if they're thoughtful and they've engaged in the process and have attempted to understand, and they ask relevant, thoughtful questions, and people that really stood out, like Tom Busey, Jay Kohler, Michael Sachs, although, again, maybe sometimes the personalities of certain people might set people off, but it's when I get a pure legal perspective or a law professor, and I just go, to me it's just the arrogance of the legal profession, because it seems like only lawyers would read about someone else's work and then suddenly have an opinion on how it should be done, or engage in that. Because I mean, I would love to submit an article to a law journal criticizing some legal opinions. I mean, we've been talking today about but we haven't talked about the law involved at all. We haven't discussed how the judge should have gone about in this case. We haven't given the judge anything that he should do. We've simply said what he did doesn't make sense according to the science and the profession. I mean, again, only it seems like a legal person could read a few articles and think that they are qualified to then engage in that practice. And I can't imagine any legal person reading a couple of medical articles and then going to the doctor and then telling them how to do surgery. I think you should really try this procedure as opposed to this one, or let me do it.
Right.
I have to just shake my. I have to shake my head. I'm in shaking my head mode.
It seems maybe when I first started, maybe it was just kind of a, the naivete of being new to the discipline, and had this kind of expectation of, if you can explain yourself, explain what you did and why you did it, and provide articles and papers and research that supports what you did, then people would get it and they would accept what you say. Now that I'm a little bit further into that, I think I may have lost that rose-colored view of things, and I don't know. I think I've started to get into a little bit different mindset of just kind of, okay, I'm going to do what I know is the right thing to do. I'm going to go about my work in the right way, based on the research that I have available to me that provides high quality work with a high degree of accuracy. And you know what? If you don't believe me, if you don't want to use my work in court, that's not my problem, really. That's for you guys to decide. I'm just going to keep doing what I'm doing because I know that this is good work. I know that people at my agency are some of the best in the world at comparing fingerprints, and we're just going to keep doing this great work. And it's, I don't know, it's more.
It's not your problem anymore.
Exactly.
I mean, you've done your job. You've done it as good as you can do. It's up to either a jury, who's usually what we're dealing with, or judge to believe us or not. And if they feel that they can do it better than us, okay. There you go. Good luck with that.
Exactly. Like if you were a doctor and the patient came in and said, I think I can do this better. All right, go right ahead.
Enjoy yourself a appendectomy.
Exactly. And in this case, again, assuming that the exemplar is as clear and matches as completely as we're imagining it does, well, you got it wrong. we can basically, without knowing ground truth, take a look at this and say, yes, Mr. Judge, or Judge Funt, is right? Funt?
Judge Funt. Justice Funt.
If you're doubting this identification, well, then you're wrong, and we can demonstrate that. And heck, we can even put it through a mathematical model that's in a testing phase right now and show how wrong you are.
It's true.
But we'll see what happens. It looks like the prosecutors are appealing this decision, arguing that the judge overstepped his bounds in bringing in information that wasn't provided to him by either the prosecution or defense. And we'll keep up to date and kind of see where this all goes. But do
you think it'll get overturned?
I got a feeling that there's going to be some people up in BC that aren't happy with this. And again, I'm not familiar enough with Canadian law to say for certain, but just from a little bit I've read over the past few days, it looks like he went a little too far than where he was supposed to go, and that this at least has a chance of getting overturned.
I'm sure it'll be overturned. I will put good money on that one. I'll take good money on that. Anyone want to take that bet? I'm sure it'll get overturned.
Well, I wouldn't bet against you there on that one, Glenn. I would not bet against you. Well,
but I guess we'll see.
Yeah, we will see, and we'll bring it back to you guys out there listening to the Double Loop podcast and let you know what we find out, when we find it out, what happens later on in this case. Well,
Yep. Okay.
Well, Glenn, anything else you want to cover? I think we've just kind of beat this topic to death.
Well, I guess I do have one more point. You mentioned
Sure.
the tangent study, and the numbers just sort of popped in my head. Real close here, but the tangent study that showed that gave basically an error rate test to latent fingerprint examiners in Australia. Their results were something like a 0.7% false positive and something like, I don't know, around 6% false negative. So, almost 1% and roughly 6% false negative. And then when they did it with lay people, the exact same test, I think it was a 25% false negative rate and something like a 55% false positive rate. So this judge would have fallen in the 1 in 4, assuming we're looking at an erroneous exclusion for the judge.
No, that is very true, and I think that's not even the only one that shows that that lay people aren't all that great at doing it. That topic seems to be well covered. That if you want to get it right, you got to talk to an expert that knows what they're doing.
Yeah, fair enough.
All right. Well, thank you all for joining us again for the Double Loop Podcast, episode 10. Thank you for being back with us again. If you have any questions for us, suggestions for shows, or just want to drop us a line and say hi and how much you like the podcast, please send an email to glenn@eliteforensicservices.com. Check back every Tuesday for new episodes of the Double Loop Podcast on SoundCloud, on iTunes, and on Stitcher. And if you can't figure out how to listen to the Double Loop Podcast, which would be kind of confusing because you're listening right now, but if you can't figure it out, or if you have a friend who can't figure it out for their device, send us a line and through email, and we'll work it out for you so that everyone can listen no matter what device they're listening on. So thank you for listening for another week, and we'll see you next week. Bye, everybody.
Bye, have a good week.
Hey everybody, be sure to check out EliteForensicServices.com for upcoming training courses. We have great workshops and courses such as Advanced HV Applications and Reducing Erroneous Exclusions. Go to www.EliteForensicServices.com today.